actually launched in February of 2000 and has featured the commentary of prominent scholars on contemporary history and politics of Ukraine. The Sochor Parry Memorial Lecture provides a time for all of us at the Institute to remember and celebrate a close friend, a brilliant but all too short career at Clark University and the Institute, a life that was taken from us well before its time. Zena was a bright light in the field of Soviet and East European history and politics, a specialist on contemporary Ukraine in academic and government circles, who began her association with HURI in the early 1980s. Her incisive, analytic mind, her quick wit, her willingness to stand up for her convictions, her high standards, won her an instant following here. She taught Ukrainian politics very successfully in our Ukrainian Summer Institute, and in the mid-90s was responsible for organizing a set of highly successful seminars at the Institute on Ukraine in a new East Central European context. Zena was among the first American scholars to teach at the Kiev-Mohyla Academy, and she earned the same high marks in the Ukrainian setting that she had garnered in the American one. She demonstrated great courage in her long battle with cancer, and we feel her absence and we miss her irrepressible smile. And I think it's fitting that today's lecture coincides with the second day of spring, although it would be hard to convince anyone that that is true. We are delighted to have with us today Zena's husband, David, her sister, Lesha, back here somewhere, yes, along with her cousin, Marika, and her uncle, Gregory. We at the Institute welcome all of you on this special occasion. Zena cared deeply about justice, order, and the rule of law, and therefore it's with particular pleasure that we welcome today's speaker, Judge Bohdan Futey of the United States Court of Federal Claims in Washington, D.C., to provide his insights on that topic here today. The rule of law and Ukraine are not two concepts that one immediately puts together. Given the high level of government intrigue, corruption, bribery, election fraud, and scandal that seems to have their hold on Ukraine for decades, if not centuries. Judge Futey received his AB and MA degrees from Western Reserve University and his Juris Doctor degree from Cleveland Marshall Law School in 1968. After serving as a private attorney and in the administration of the city of Cleveland, he accepted the chairmanship of the Foreign Claims Settlement Commission of the United States in 1984, and he was finally appointed to the federal bench in 1987. Judge Futey is actively involved with democratization and rule of law programs organized by the Judicial Congress of the United States, the Department of State, and the American Bar Association in Ukraine and Russia. He has participated in judicial exchange programs, seminars and workshops, and has been a consultant to the working group on Ukraine's constitution and Ukrainian parliament. He's also served as an official observer during the parliamentary and presidential elections in Ukraine since 1994. Judge Futey teaches comparative legal systems for LLM students at the Law School of the National University of Kiev-Mohyla Academy and has taught constitutional law at Ukrainian Free University in Munich. His numerous publications include articles on constitutional law, the role of the judiciary, and elections and the law. His 2001 book, Establishing the Rule of Law, Ukraine, 1991-2001, was updated and republished in 2005. Judge Futey is the recipient of numerous awards. If I listed them all, we would be here past 6 o'clock. But I'll simply highlight some of them. The 1987 Man of the Year Achievement Award from the Ukrainian Institute of America, the 1995 and 1999 Ukraine President's Award, the 2006 U.S. Court of Federal Claims James Madison Award. He has been accorded honorary doctoral degrees by Ukrainian Free University in Munich, the Subcarpathian University in Ivano-Frankivsk, the Transcarpathian State University in Uzhhorod, and the National University of Kiev-Mohyla Academy. Today he will speak on the topic, the rule of law and constitutional guarantees in Ukraine. It's a pleasure to welcome Judge Futey.
Well, thank you very much for that kind introduction. Indeed, it's a pleasure and honor to be here at the Ukrainian Research Institute at Harvard University. Just for information to those that are not aware, as president of the Federation of Ukrainian Students way back in 1963, we were instrumental in fundraising for the Institute that the Federation of Ukrainian Students did for a number of years, starting in '61 and then continuing until it was finally signed. The agreement was signed by Dr. Kulchitsky as president of the Federation and the Institute. So I take some pleasure and pride in being part of the Institute from day one, so to speak. Again, it's also an honor to be part of the Zenovia Sochor Parry Memorial Lecture Program, and I read articles published, and I really think that her contribution to the research to the Research Institute, as well as the Harvard University and to Mohela University, will be remembered by many for many years to come. It's a topic that it's a favorite of mine to talk about rule of law, constitution, and the judiciary. I also, before I forget, I'd like to recognize and acknowledge a lot of people that I know yet from way back, and they're here also today from those early days, so it's a pleasure to be with all of you. And let me just say this, that 2 weeks from today, we'll be commemorating the 301st anniversary of the Constitution of Philip Orlik. The Constitution of Philip Orlik was signed, the document was signed on April 5th, 1710, almost 80 years before the Constitution of the United States of America. And the document contained such things as separation, a concept of separation of powers, a separate judicial tribunal, as well as the concept of private ownership of property. That's extremely important in the developments that follow in Ukraine and Europe and other parts of the world. Also, let me mention the case of Marbury v. Madison that was enacted or decided on February 24th, 1803. And the reason I'm mentioning this case is because there is some connection between Marbury v. Madison and the Ukrainian embassy in Washington, D.C. I'm sure that Mr. Vibrova knows about it. There are 2 plaques on this building. One plaque says is about the visit of George Washington, General Washington, with the mayor of Washington to obtain more land for the city of Washington, for the District of Columbia. And the other one is the fact that William Marbury, of the Marbury v. Madison fame, lived in that building. So when the visitors come in, we do talk about the judiciary. We talked about rule of law to them from the building or inside the building. So that is extremely important. Let me also mention to you that Ukraine will be celebrating soon 20 years of independence. That is in August. And it took 3 acts for Ukraine to reestablish its independence. First was the Declaration of Sovereignty on July 16, 1990. Then the Declaration of Independence on August 24, 91. But that was subject to a national referendum on December 1st, 1991, and during this referendum, over 91% of the people voted for that referendum. A recent poll last week conducted basically changes those figures and says that only 53 to 51% of the people would vote for independence at this time. So some things have changed or are changing. Nostalgia for the past, and 47% support being part of what once was the Soviet Union. That is not a good sign. And we are close to almost 15 years of the adoption of Ukraine's constitution on June 28, 1996. And again, the Constitution introduces the concept of separation of powers. Article 6, Article 8 talks about the rule of law. And the Constitution, by the way, had the guarantee of human rights. And for that particular, for those guarantees, the Constitution received recognition and commendation for a number of international organizations at that time, including the Venice Commission and the Council of Europe. Now, let me just simply say that in talking about the rule of law, one has to say that it is the linchpin to promote democracy throughout the world, and democracy in turn will provide a better and more prosperous economic life. There are many characteristics of the rule of law. Let me just mention what I consider to be essential in the context of my presentation. Number one, we're talking about the supremacy of the law, which means that all persons, individuals and government officials, are subject to the law in the same way. No person should be above the law, regardless of his or her status. We're talking about the rule of law, not the law of the rule. An example of the latter would be the Nazi regime in Germany and the Soviet Union under the Communist Party. Next, the source of the law must be the people themselves. A concept of justice which emphasizes interpersonal adjudication, law based on the standards and the importance of procedures. Just want to remind you that President Abraham Lincoln, speaking before the Congress in 1861 about the establishment of the court where I now sit, the U.S. Court of Claims at that time, said, "It is much the duty of government to render prompt justice against itself in favor of its citizens as it is to administer the same between private individuals." Next is the preservation of individual liberties, free speech, peaceful assembly, freedom of the press, worship as one pleases, equal opportunity, due process of law, right to counsel, and independent judiciary. Without the courts to assure that human rights, especially those of minorities or unpopular groups, are enforced, many provisions of the Constitution will be reduced to pieces of paper. The legislation next should be prospective and not retrospective. Next, a political system based on the separation of powers, as I mentioned before, with appropriate checks and balances, and an independent judiciary. As there cannot be a market economy without private ownership of property, there cannot be respect for the rule of law unless there is an independent judiciary. We look forward to the courts to promote democracy and the rule of law. At the ABA International Conference on Rule of Law, held on November 4th, 2005, in Washington, D.C., Justice Sandra Day O'Connor noted that the decision by the Supreme Court of Ukraine in the case of Yushchenko v. the Central Election Commission was a recent example to promote the rule of law in Ukraine as well as an example in the world. Against this backdrop, let me point out that the unified court system, typical of common law countries, is in contrast to the several separate courts that often coexist in civil law countries. While a typical common law country in its judicial system is described as a pyramid with the Supreme Court on top, a typical civil law judicial system is represented as a set of 2 or 3 or 4 separate specialized courts having its priority of its own. Ukraine does not have a unified judicial system like the United States, but is fragmented. It is closer to European models. Ukraine's current judicial system, however, represents a substantial improvement over the outdated system dating back to the Soviet Union. The establishment of a constitutional court and courts of general jurisdiction have brought the judiciary closer in serving its much-needed role in Ukraine in its search for democracy. Now, let me say that since 1992, there were 2 commissions that worked on the present constitution of Ukraine. One led by President Kravchuk, the first president, the other by President Kuchma. To assist the commission in its task, there was a working group chaired by Professor Leonid Yuskov, of which I, as you heard, was a member of this working group. The Ukrainian Legal Foundation, the International Foundation for Election Systems, IFES, and the World Congress of Ukrainian Lawyers also assisted with conferences and analysis of various drafts. For your information, there is a new commission in Ukraine at the present time, established by President Yanukovych. It's called the National Constitutional Assembly, and it's chaired again by the first president of Ukraine, President Leonid Kravchuk. Its future or its significance at this time is still unknown. In an overnight session from June 27 through June 28, the Verkhovna Rada of Ukraine, the parliament, debated and eventually passed the constitution. The movement to pass the constitution was led by deputies Moroz at that time, Serota, now deceased, Holovati, Stretovich, and Yemet, also deceased. With the adoption of its constitution on that day, Ukraine took yet another step toward joining the community of democratic nations that place the rule of law and free market economic system among its highest values. The process that culminated with the adoption of the Constitution was by no means solely one of agreement and harmony. Rather, as one might expect, the Constitution was born out of compromise. As for example, the vote for Ukrainian to be the state language and keeping the name of Autonomous Republic of Crimea had a significance on the adoption of this Constitution. The Constitution addressed the concern of Ukrainians about their national interest, the establishment of their statehood, as well as the suppression of rights by the Soviet Union, at the same time, what kind of social change the democratic future would bring. The Constitution was commended by a number of international organizations, and I said especially the Venice Commission, the Council of Europe for its protection of human rights. The Constitution contains what we know in the United States as negative rights and positive rights. Negative rights, they are inarticulated individual rights. The Constitution includes both of these. Negative rights protect against government interference by limiting the role of government. They establish basic private rights and personal freedoms, such as freedom of speech, press, religion, and assembly. Negative rights are enforceable under the rule of law. A court may declare a policy or enactment of the government improper or illegal. Positive rights require the government to do something for the benefit of the individual. They include the right to a job, the right to housing, the right to a satisfactory living condition or standard. They are, however, very difficult to enforce without further legislation. Many critics believe, therefore, that these rights should be placed preferably in the preamble of the Constitution. In other words, what the country, what the government is seeking to accomplish, and not a guarantee. The Czech Republic has done that, and many other countries of Eastern Europe. Attempts to adopt legislation that enforce these positive rights have been difficult to pass. Often legislation based on these positive rights clash with negative rights guaranteed by the Constitution. As I said, it should contain a concept of separation of powers, and Article 6 of the Constitution provides for this, dividing the government into the executive, legislative, and judicial. The concept of checks and balances exists, but has not been really developed and established in practice. The rule of law, Article 8 declares that the rule of law is recognized and effective. Private ownership of property, again, is stated. Free speech and press, as I stated. And we must say that during President Yushchenko's administration, the press has been freely commenting on the members of President's family, the Secretariat, the Cabinet of Ministers' lavish living. Many reports have been made on events that would not have come to light in the previous administrations. Recently, however, the visit of the SBU representatives to the president of the Catholic University in Lviv, the cancellation of airways for TV broadcast frequencies to Channel 5 and TVI, together with attempts to pass a new law by the Rada to restrict protests, especially those concerning the tax code, and the right of assembly has put these rights in jeopardy, as well as targeting of opposition leaders for investigation, as well as restrictions to travel abroad. The free elections concepts, the right to vote, which is guaranteed by the Constitution, has been increasingly well enforced, particularly following the Orange Revolution, up to the recent election of the president. However, the local elections recently held has not received the approval or the commendation of international observers. There is a problem with local elections in the law, the way it was adopted. And just 2 or 3 days ago, you read a story that again raises the question about the future of the new election law to Parliament. We'll talk a little more about that, but the problem is that the new election law is being worked out for election of Parliament, basically changing the proportional system to half and half, majoritarian and proportional, and is under the leadership of the Minister of Justice, Alexander Lavrinovich, and as of 2 days ago, 3 days ago, the National Democratic Institute, NDI, has left the working group, has withdrawn from the working group because of the concerns that the rule of law might not be enforced. Let me just briefly, I'll get back to it, say something about the Constitutional Court. When the Constitution was adopted, a judicial system was adopted for courts of general jurisdiction. I'll talk about it, and also the Constitutional Court to deal with the interpretation and issues of constitutionality. There are 18 judges, 6 appointed by the President, 6 elected by the Council of Judges, and 6 elected by Parliament. The terms is 9 years, no reappointment. And there have been some positive decisions by the first court dealing with the residents of Zloty Vody. Citizens have access to the courts for protection of their rights. The case of Ustimenko 97 guarantees the right to obtain information about oneself. The case of dual mandates, the Constitutional Court said that you should not have 2 mandates. But that has not been kept to the extent that it should have been, because until even recently there were judges, and they were also members of Parliament. Now they were members of Parliament and holding another job in the government. So that is not proper. Then there were negative decisions. You know about it, that a president may be elected by Parliament under the present Constitution, then allowing the President Kuchma, to run for the 3rd term. He didn't do it. And recently there has been a decision in 2008, on April 8, that the Constitutional Court again raised the issue of judicial independence. I will not dwell in the court's decision because I believe that the court, by its majority, may decide what it wants, but the problem is what it leaves after such a decision: mass confusion and chaos. We'll get to that yet. Also, just recently, the court on September 30th invalidated the political reform that was adopted in order to stop the fraudulent elections in 2004. The court held that it was unconstitutional and invalid. The problem with the Constitutional Court, the problem with some laws are adopted in Ukraine, unfortunately, that either contradict other laws or contradict the Constitution itself. The constitutional law in the Constitutional Court provides that judges of the Constitutional Court must take the oath of office in Parliament, an open session of Parliament. So that means if the Parliament doesn't schedule an open session for the oath of office, nothing happens. No quorum would exist. And that's what happened in Ukraine for 10 months. For 10 months, from October 2005 until for 10 months, there was no quorum of the Constitutional Court, and the court could not decide anything because the president, because there was no schedule. So in other words, Parliament is controlling, political control over the judiciary, which is not in line with the rule of law on the concept of judicial independence. All right. Now let me talk a little bit about the judiciary itself. The way the Constitution was enacted, it allowed the courts to exist the way they were existing for 5 years, and provided for the courts to be in effect in accordance with the Constitution 5 years thereafter. So that would be 2001. The way the courts are set up in Ukraine, as I mentioned, you have the Constitutional Court, and then you have courts of general jurisdiction. Article 124 states that the judicial proceedings are performed by the Constitutional Court of Ukraine and courts of general jurisdiction. Then it says that the people directly participate in the administration of justice through the people's assessors and juries. But then Article 125, which is crucial with the present system, what's happening right now, says that the Supreme Court of Ukraine is the higher judicial body in the system of courts of general jurisdiction. And the respective high courts are the higher judicial bodies of specialized courts. So far, under the new law on the judiciary that we'll talk, you have the commercial specialized court, you have the administrative specialized court, and you have the civil and criminal specialized court. So you have those specialized courts with their higher courts on top. Then you have the Supreme Court, and then you have the Constitutional Court. That's the way the system exists. Now it took them 5 years to adapt to the Constitution. 2001, nothing was happening, and that's when the 5 years were up. So very quickly, very rapidly, and thanks to U.S. Ambassador Carlos Pascual, that we worked very closely with, he brought in everyone and said, hey guys, we better do something, otherwise there will be chaos. The Ukraine's courts will not comply with the Constitution. So a law on the judiciary was adopted. And that law was called the Small Law on the Judiciary. All right, so 2001, we have the Small Law on the Judiciary. Comes President Yushchenko, and in 2006, through its commission or committee to strengthen democracy and rule of law, headed by Minister Onyszczuk, tries to pass a concept of reforming the judiciary. The problem with that was that in reforming the judiciary, the president tried to really put the judiciary in control, or have the executive to have control of the judiciary. All executives try that. Some of them succeed on that. And he had the practice that he would summon in the judges of various courts and teach them, lecture to them how the judges should act independently. And then when he did not like the decision of the courts, he would liquidate the courts, abolish them. So it would take a higher court to reestablish that court. Or if he would not like the decision, and this is President Yushchenko, he would not like the decision by a certain judges, he will fire the judges for violating the oath of office. As happened to former Minister of Justice, Zuzanna Stani. Zuzanna Stani had her own problems. But before you can fire somebody for violating the oath of office, there has to be a definition, there has to be a concept, what constitutes violation of the oath of office. Anyway, so that was the second. However, that concept, President Yushchenko's concept was never adopted by the Rada, so that went away. Now comes President Yanukovych, and Parliament passes 1, 2, 3 on the second reading, the law reforming the judiciary and the status of judges. It's passed, adopted by the Rada on July 7th and signed into law by the President on July 27th of last year. And then all of a sudden the Venice Commission, Council of Europe, the rule of law of the United States, and program, we all start saying, hey, wait a minute, you did not hear what we were saying? Some of these things really are improper, are in violation of the Constitution and a violation of the rule of law. All right, so let me just say that a strong judiciary must be co-equal with the other branches of government. This means that the judiciary and each individual judge must act co-equal with and independent from the other branches of government. The new law contains some improvements, I have to admit, that will help the judiciary in Ukraine to become more independent. Positive and progressive provisions of the law to ensure the judicial independence are as follows. But there is a conference, by the way, on this topic that I'm touching right now in Lviv, starting Thursday and Friday. And I will be participating via Skype because I opted to be here rather to be in Lviv at this time and to share my thoughts with you. But these are the thoughts that we'll be discussing in Lviv. The selection process of judges has been made better. And I'm not going to go into too many details. It has been made better. There will be tested under video surveillance and within the anonymous testing system. And more or less what Georgia has adopted when Shekashvili became a Minister of Justice in Georgia and later on became the President. It also would be facilitating the report of threats to judicial independence. We'll see. There will be an automatic random case assignment among the judges, rather than the chief judge coming in and saying, I want you to handle this case, because my friend brought this case, and remember that, my friend brought it. Okay. So now it's a bit different. The inclusion of the state administration under the judicial control. So it'll be part of the judicial branch rather than the executive. Improvement of financing the courts. This would be, again, that it will be a general system. Under the old system, the Supreme Court had its budget, the Constitutional Court had its budget, and the higher specialized court had their budget. All the lower courts depended on the state administration. So really the Supreme Court did not care about the lower courts, nor no one else cared about that. So that was a big problem. That has been changed. The financial disclosure requirements. I say that because we in the United States are required 2 financial disclosures. One to Congress, one to the Judiciary, and it's due right now on May 15th, and one to members of the Senate, to see what we are doing. For example, that I'm participating here and not being at my work at the courthouse, I would have to say that this is beyond my assigned court activities. This is rule of law, but not my assigned court activities, so I have to report. Training of judges, this will again be improved. Improvement of discipline practice procedures, hopefully will be, I'll talk about it more. Reduction of justices of the Supreme Court, that's an improvement. Guess how many justices of the Supreme Court were when Yushchenko took office, and he amended that. So when he left, it was close to 100 justices of the Supreme Court. Now it has been reduced to 20 members. There will be 20 justices of the Supreme Court. Political neutrality. I mean, judges are prohibited from being members of political parties and belonging to trade unions. However, a judge, as happened to the former chief judge of the commercial court, he was a judge, the chief judge, and he ran for parliament. And he was elected without resigning. There were other judges that ran, were not elected, and went back to be judges. That, in my view, creates a very, very difficult problem for what is happening. All right. While the new law, as I said, contains many improvements that will help the judiciary become more political, the law has also several areas where it can be improved. For example, the involvement of the higher council of judges. The higher council of justice. And the High Qualification Commission in the selection process. While the High Qualification Commission is composed mostly of judges, the Higher Council of Justice is not. It's too political. It's under control of the president completely. And the political party, well, can you imagine the head of the SBU is member of this body, and it controls the elective process. I know what you can say to me, the judge, but do you know that the U.S. also has a political process? Yes, if there is such a question, I will explain it. Judicial independence does not mean that judges can do whatever they want. Some form of judicial immunity is critical. Right now, judges cannot be prosecuted, cannot be brought to justice unless Parliament votes for it and the general prosecutor begins that activity. The new law requires a judge to comply with the Code of Judicial Ethics. We have been working with judicial ethics in Ukraine. And, you know, our Code of Judicial Ethics of conduct, if we violate it, we can be brought up to disciplinary procedures. When we talk to Ukrainian judges, says, oh, we have it too. I said, okay, fine. But then you read the preamble, and the preamble of that code says, violation of any of these provisions may not be used for disciplinary measures of judges. And that is because they have this idea that a law has to be enacted. They will not be controlled by their own codes. Well, if the judiciary is to be independent, it has to be controlled, it has to be done by its own discipline. All right. Okay, again, the law foresees that a judge can be dismissed for a breach of oath. Well, there's no definition of breach of oath, and again, a problem. There are other things, for example, that now constitutional controversy in the decreasing role of the Supreme Court of Ukraine exists under the new law. The Supreme Court under the Constitution is the highest judicial body within the courts of general jurisdiction. However, pursuant to the new law, the high specialized courts will now decide whether to submit cases on questions of law, cassation, to the Supreme Court. So they will be the highest courts, not the Supreme Court. So the role of the Supreme Court, even though the Constitution guarantees it to be supreme, is not clear what will happen. The other problem is that the law requires that the judges take the oath of office in the presence of the president. Can you imagine what would happen? The president will never show up unless the judge will be deciding cases at the expectation of that individual. So again, you can have a problem. That has to be changed because it's unconstitutional. Okay, again, you have jury trials. Well, there hasn't been a jury trial in Ukraine since day one. So either you have a jury trial or not. So you really need to make these amendments, you need to make these changes in order for the law to be in accordance with the Constitution. And I am getting to the last part of my presentation, and that is basically the chaos that has been established, uncertainty with the latest decisions of the Constitutional Court of Ukraine. The decision of the Constitutional Court of Ukraine of September 30, 2010, concerning the political reform is an abrupt change of course. You probably realize that because of the fraudulent elections, presidential elections in 2004, and the decision by the Supreme Court, that's why I said at the beginning, Yushchenko v. the Central Election Commission, the Rada adopted amendments setting up the political reform. I said from day one that those amendments were unconstitutional. Unfortunately, the president at that time didn't want to listen to that because his ally was Deputy Moroz, and they were in a strong alliance. And then 3 months later, Mr. Moroz left the president, as you know, so the alliance was gone. But anyway, and why was it improper? It was improper because it was adopted in a very hurried up manner, just to satisfy certain things. It settled the presidential election, but created other problems. In a decision by the Constitutional Court on October 5, 2005, the court said that any change in the political system besides the regular requirements of the Constitution, Articles 154 through 159, would require also a national referendum. There was no referendum. So by that effect, the political reform was not proper. It was not proper also procedurally, as this court had said, because each separate amendment, or each amendment must be voted separately. And here it was voted in the package. And third, the Constitution says that you may not introduce amendments to be approved until after the next session of Parliament. And this was still, some of these items were the same that were rejected in the spring of 2004. So it was illegal and improperly done. All right. The political reform was passed by the Verkhovna Rada in response to the fraudulent presidential runoff election in 2004. The amendments resolved the electoral crisis but were hastily adopted and not passed in accordance with required constitutional procedures. And I told you why not. Now, the procedure for adopting the political reform were challenged, now listen to this, were challenged yet in 2008. 102 deputies, legislators, petitioned the Constitutional Court to review the procedures for adopting those changes. The court dismissed the challenge in February of 2008. The court said that you cannot challenge the law already because the law is no longer the law. It's part of the Constitution. So you cannot challenge it. That was February 2008. On September 30th, 2010, in response to the request of 252 legislators, the court issued a decision that reviewed the constitutionality of the law and said that the law was unconstitutional. Nothing has changed except there is a different president. The decision, as I see it, is illegitimate since the procedure, the decision is legitimate since the procedure for enacting the political reform were unconstitutional. Despite the legitimacy, however, the decision has a number of far-reaching consequences. The decision may undermine the rule of law since the court has now rendered inconsistent decisions. It is a risky practice for a democratic state to have its highest court issue conflicting decisions without thoroughly explaining the reasons. You can do that. Brown versus Board of Education, explaining Plessy versus Ferguson. You can do that, but it requires some explanation. Legal reasoning can certainly change over time, but the court should have dealt and explicitly invalidated its prior decision to avoid legal inconsistency. Now, the substance of the court's decision says that the political reform adopted is no longer valid, so the Constitution, see, I kept it, of 1996 is valid, not the changes of 2004. But it did so without including specific directives regarding the legitimacy of the institutions. And the worst problem that was set up is concerning the election to Parliament and the President. Under the old Constitution, Parliament's 4 years. Under the political reform, 5 years. Elections should have been held in March of this year. Well, the Constitution, the Parliament petitioned and the Constitutional Court said, well, yeah, that is unconstitutional, the political reform, but the people were voting for these individuals for 5 years, so let them stay for 5 years. Well, not logic, not at all. And the same thing, the situation now with the president, okay? So that would be a different thing that will happen. All right. Now, I am coming to an end because probably the time is running out. In my opinion, Now, as far as reforming